students, welcome back to iProledge. My name is Theja. So we have started with revision series for JIGL. So we are back with the next chapter, that is chapter 1, sources of law. Now this chapter, a lot of students find it very boring because they feel, ma'am, there are so many things that we have to remember, legal theories and all of that. No need to worry, we are here to simplify things. So this chapter, easily you can expect around 5 marks from this chapter. Now, it is an important chapter. This chapter tells what is law, how has law evolved from ages, what is the different definitions given by different juries about law, right? It is a very, very interesting chapter actually. So we are here to make this chapter fun and interesting. Let's start. All right. Okay, so the first question is, what is law? A very simple question. Before that, let me ask you another question. What is the subject? It is jurisprudence. What do you mean by the word jurisprudence? See, jurisprudence, the meaning of that word jurisprudence is, it is the study of law. It is the study of law. Okay, it talks about the philosophy of law. It addresses what is law, why law exists, and how does law work in a society. This is the meaning of jurisprudence. It does not only talks about the rules. It lays down what are the principles behind those rules. Okay, this is the meaning of the word jurisprudence. What is jurisprudence? It talks about three things. What is law? Why law exists? And how does law work in the society? Okay, now my next question. What is law? In simple, what is law? It is the body of rules and regulations made by the recognized legal system, and it is enforced by the state. Rules, principles that is made by the recognized legal system, and there is an enforcement body who enforces it. Right? Alright. Now your Article 13(3). It has defined what is law. Article 13(3) of Constitution gives a wide meaning to law. It includes, according to Article 13(3), what all is included in the definition of law: ordinances, orders, bylaws, rules, regulation, notification, customs, everything. So this we have covered in detail in Article 13 where I have explained. So please go through that video if you have not watched it. And then, what is the significance of law? Now law has evolved over centuries, right? No? It was there much prior. So it has evolved over the time. Judicial decisions, customs and conventions, all of your practices that has been followed shapes the present legal system. So there has been a lot of customs that were followed, practices, traditions, and over the period of time, all of those collectively has evolved the legal system, defining what law is, right? So law is not static. It changes with changing social, economical and political conditions of the society. So based on the changing society, even law changes. Now, relevance of law to civil society. Now we have three things. One is the government, one is the lawmaking authority who makes law, and then is this businessman who makes profit. There is this another community who works independently, your NGOs, all of that. They all collectively come under civil society. So law performs many functions to support and regulate civil society. We have laws to support them, correct? Both in theory and in practice. So proper distinction and balance in applying law is necessary. Otherwise, law may restrict or suppress the civil society. That should not happen. It should not suppress the civil society. Whatever law you are making, it has to be for the benefit of them. You should promote them, not restrict them. So this is what you have to remember. So when law becomes overly restrictive, what happens? It may limit the freedom, leading to a negative perception of law among people. That should not be the intention of law, right? Next, what do you mean by jurisprudence? It is the study of law, philosophy of law. It tells three things. What are those? What is law? Why law exists? How law should work in the society? Now, what are this legal theory? See, this particular chapter, chapter 1, there are 3 segments. First segment is the legal theory. What is legal theory? Different jurists, different expert of law, they have defined what is law according to them over a period of time. That is legal theory. Okay, so here we have a lot of theories that we will go through. In this, we have mainly 2 legal theories. First is positive legal theory. The second one is normative legal theory. What is this legal theory? All the theories of law. We have 2 parts, positive legal theory and normative legal theory. What is positive legal theory? Positive legal theory explains what law as it is. Positive legal theory says, this is law, read it as it is. Do not check whether it is right or wrong. Do not check whether it is immoral or not. Do not get into the morality of the law. Only check law as it is. Did a proper authority pass this law? If yes, then that is how you have to read it, as it is. You're not going to get into the morality aspect. This is positive legal theory. What is positive legal theory? They will only check one thing. Oh, there is a proper authority and this authority validly passed a law. If it has a proper authority and it has passed a law, that means that is the final. You have to read law as it is. You are not getting into the morality aspect. You are not getting into whether this law is correct or not. All of that you will not check. And the opposite of this is normative legal theory, who checks whether this law is good or not. So normative legal theory explains what the law ought to be. Understood the 2 legal theories? Alright. So we have a lot of important legal theories. So now first we will understand all the jurists, how have they defined law according to them. So as I said, you have 3 parts. First is what is the definition of law as per all the jurists, and then you have school of law, different schools of law, and then you have what are the sources of law. That's all. You understand these 3 things, divide this chapter into these 3 things, you are done with this chapter. Alright. So first person is Jeremy Bentham. What did this person say? See, Jeremy Bentham is known as the father of analytical jurisprudence in Britain. Now what is analytical jurisprudence? Analytical jurisprudence says what law as it is. Read law as it is. They are all positivist legal theory. Okay, they don't get into the morality aspect. Only see whether the proper authority passed. Read law as it is. Okay. So according to Bentham, law is the command of sovereign and it is imperative in nature. There is a sovereign, that is the supreme authority who is making law. That authority, it commands whom? People. Okay, so it is a command by the sovereign to the people. According to Jeremy Bentham, what is law? It is the command by the sovereign to whom? To the people. So sovereign is telling, it is giving a command. Command is what? To do something or not to do something. Ordering people to follow it. This is law according to Jeremy Bentham. So Bentham's philosophy is based on utilitarian, principle of utilitarian. What is principle of utilitarian? It says that law should aim at maximum happiness of the maximum number. Maximum people should be happy. That is the principle of utilitarian, and that is what law has to achieve according to Jeremy Bentham. Got it? And then second principle what he explained was principle of pleasure and pain. That is, the purpose of law is to promote pleasure and reduce pain for the whole society. Okay, so he laid down 2 principles, principle of utilitarian, principle of pleasure and pain. Achieve maximum happiness for the maximum people. Promote pleasure, reduce pain. Okay, so according to him, a good law should be complete, clear, well coordinated, so that intention of the legislature is properly expressed. Hence, law expresses the will of the sovereign backed by sanctions. What is sanction? Punishment. According to Jeremy Bentham, sovereign commands the people to follow the law. But will people just follow without any sanction, without any punishment? No, right? So he says that law should back sanctions. Okay, there has to be a punishment, only then people follow it. This is what Jeremy Bentham has told. Quickly, when the question is asked about Jeremy Bentham, what all you're going to write? First thing is, Jeremy Bentham is the father of analytical jurisprudence. He is a positivist. He is the person who believe in positive legal theory, which says read law as it is, do not get into the morality aspect. Second thing, he has explained two principles of utilitarian and principle of pleasure and pain. That is, the purpose of law is to make sure that maximum number of people are happy, right? Increase the pleasure and reduce the pain. And then law should always be backed by sanction. And how should law be? It has to be clear, well coordinated, so that the intention of the legislature is properly expressed. Clear? All of you clear, Jeremy Bentham? Now definitely a lot of other people would have criticized his theory. What did they say? According to others, they have criticized the Bentham's theory, telling that it is too narrow. Why it is too narrow? Because Bentham treated all the laws as command or permission, ignoring laws that confer powers. Bentham is telling law is a command. That is, people either they have to follow or don't follow. To do something or not to do something. You are ordering. But there are a lot of other laws which gives you powers, which gives you rights to do something. For example, your contract law. Now, contract law isn't an obligation. Is there any obligation that every single person should have to get into contract? No. It says if you get into contract, these are the powers you get because of this law. These are the rights that you get. You can make use of these rights. Right? These are the laws that gives power to people. He's ignoring that aspect. He's only talking about those laws that gives a command. Right? So this is the first criticism. Second is, he did not properly recognize custom as a source of law. Now even custom is a source of law. What is custom? All the practices, all the traditional practices that have been followed over a period of time. Very old practices that people have been following, and those practices are recognized by law. These are customs, and he ignored that aspect. And then he said there is no place for judge-made law. Bentham rejected judicial precedents and believed judge-made law should disappear once complete codified law exists. Now you know there are two legal systems, civil law legal system and common law. What is civil law focuses on? Civil law tells there has to be a codified law. If you have a codified act, that means you are following civil law legal system. What is common law legal system? If you are following judge-made law, there is no codified act. Now we have already covered law of tort in your earlier video. What is that? Is there any act? Is there tort act? No, right? It is based on common law legal system where there is no codified act. It is based on judge-made principles. We have seen so many case laws there. Through those case laws, principles are derived. Okay, so that is your common law legal system. He ignores the common law legal system and says there has to be mandatorily codified law. And then the fourth criticism, Bentham says utilitarian principle, right? So his utilitarian test is subjective, of course. And he failed to explain how the pleasure and pain can be measured objectively. Now, among 100, 80 people are happy, 20 people are not happy. How do you measure that? And secondly, how can you say that everyone will be happy? It's impossible. There would be some community who would not be happy. So measuring that is very subjective and difficult. These were the four criticisms of the Jeremy Bentham principle. Clear, all of you? Who is Jeremy Bentham? Father of analytical school of law. He says what law, read law as it is, and another thing what most importantly he says is law is the command of sovereign. Everyone has to follow it. Two principles, utilitarian principle and principle of pleasure and pain. And then these are the four criticisms. This is about the first theory which is given by Jeremy Bentham. Clear? Alright. So that another point what we missed is, yeah, so happiness of all is not guaranteed. The same thing. Increasing happiness of one group may reduce the happiness of other. How do you measure it? There would be imbalance there. How do you balance that? He didn't say that. So this is a criticism. Next, John Austin. This is the second one. First is Jeremy Bentham. Second is John Austin. He has spoken about command theory of law. Okay. So even John Austin is a positivist, where they see, I'm repeating again, you should not forget. What is positivist? They read law as it is without touching the morality aspect. Okay. So meaning of law according to Austin, law is the command of sovereign backed by sanction. What did he say? It is the command of sovereign backed by sanction. Command, sovereign, sanction. These three things. Who has defined it? It is John Austin. All of you clear? Who has defined these three things? It is John Austin. According to John Austin, there are three things, three essential elements of law. Command, sovereign and sanction. Alright, now you tell me, what do you mean by command? Command is an expression of will directing a person to do something or not to do something, right? I am ordering you, you have to study this chapter, else you have a punishment. Command is given by the authority. If you don't follow, you have a punishment. Command given by the sovereign, backed by the sanction if you don't follow it. Got it? Simple way. What is a command? To do something or not to do something. You don't have an option there. And if you don't do that, you have a punishment. And who is telling that? It's the sovereign body. It is the authority. Law-making authority. Sovereign body. Clear? Yes. So what is sovereign? Sovereign is a person or body that receives habitual obedience from people. Sovereign is the source of all law. It is the body who has the authority to make law. Sanction is punishment for disobedience of law. Simple? Clear? Now we will understand what are the criticism of Austin's command theory. Just a minute. Alright, let's continue. Okay, next. Now we will be discussing what were the criticism of John Austin. What was his criticism? According to others, he ignores welfare legislation. That means many modern laws confer rights and benefits rather than impose command. Right? No, in this modern society, does this command work? No, they confer rights and benefits. Right? That is what social welfare is. If you are only talking about command, would you achieve social welfare? No. So the next point is, sovereign is not absolute today. Modern sovereigns are limited by constitution and international law. What it says, yes, sovereign has the authority to make law, but can you go against constitution while making law? No. You have derived your power from the constitution. Even if you are the supreme authority of lawmaking, you have to follow someone above you. That is constitution. You have to follow international laws. Correct? Next is judge-made law ignored. Even Bentham ignored, even he ignored. So Austin denied that judge makes law. But in reality, judicial precedents create law. Right? Next is international law is excluded. Austin did not recognize international laws as law since, according to him, international law is not a law. Why? Because there is no sovereign or sanction. See, international law protects all the countries, protects all the states. So according to him, this is not a law because it is not backed by sanction. So according to him, only that is backed by sanction is law. Right? So there is no sovereign. So according to him, three things are there: command, sovereign, sanction. Law is backed by the sovereign. Law is a command given by the sovereign, backed by sanction. Clear? What did Jeremy Bentham say? What did John Austin say? Yes? All of you with me? Yes. Next. John William Salomon. Now this person is a judge. So what does he say? He's a judge. He says that purpose of law, according to him, the main purpose of law is administration of justice. This is what a judge say, right? So connect it. Salomon is a judge. According to judge, what is it? Law purpose is to administer justice. Unlike Bentham and Austin, who focus more on command and authority, he focused on what is the purpose of law? To administer justice. Now, law depends on the state. Although Salomon emphasized justice, he agreed with Bentham and Austin that law requires the authority of the state. Yes, he says, yes, law is based on law. The purpose of law is to administer justice. But definitely there has to be an authority. Even that he agrees. Okay. Now, he has differentiated what is a law, what is the law. You have to remember this. A law refers to specific statute. Now, there is Right to Information Act, Contract Act, a law, specific statute. The law refers to the abstract system of legal principles like civil law as a whole, criminal law as a whole. So, this is the law. Alright, simple. Next, definition of law. Salomon defined law as a body of principles recognized and applied by the state in administration of justice. The above two people did not talk about justice. This person is talking about justice. Law consists of legal principles, not merely the total number of statutes. So according to him, justice, administering justice comes first and then the law. So administration of justice comes first. Salomon argued that administration of justice is the primary and law are secondary. They exist to help the courts administer justice effectively. So this is what Salomon has told. What is that you have to remember here? Administration of justice. And he has differentiated a law and the law. Okay. Now, justice cannot exist without some form of compulsion. Even he believes that. Yes, some kind of punishment has to be there. Only then justice gets its value. The state uses the force and sanctions to uphold the justice, while society enforces morality through social sanctions like criticism or contempt. Now, according to him, when will the legal system be developed? A developed legal system evolves with when judicial discretion is gradually replaced by fixed principles from sources like precedent, custom, statute. So from judicial discretion, that has to be replaced by statutes, precedents and all of that. When that shift happens, at that time the real growth of legal system is there according to Salomon. Understood? So what was his criticism? So what did other people criticize? Justice is not always the end of law, of course, right? So many laws may be valid but unjust. So justice cannot always be treated as the sole purpose of law. No, that is not the sole purpose. Law serves multiple purposes. Law does not only serve justice, it also serves social order, control, welfare, policy goals, which changes over the time. Salomon treats justice as universal but limits jurisprudence to national civil law, which appears inconsistent. He is telling justice is universal, that everyone has to follow. At the same time, the jurisprudence, but limits the jurisprudence, the study of law, to only the national limits, that is within the country. But he is telling it is universal, everyone has to follow. It is inconsistent here. Understood? Jeremy Bentham, John Austin and Salomon. Alright. Next, Roscoe Pound. What did Roscoe Pound say? He was a leading American jurist and the main proponent of sociological jurisprudence. Now this person has entered who has brought in societal welfare, social welfare. He has touched the concept of sociological jurisprudence. That jurisprudence which studies law along with society. Now the theory of social engineering. Pound compared a lawyer to an engineer. The aim of the law is to build an efficient society by satisfying maximum human wants with minimum friction and conflict. So according to Pound, Roscoe Pound, what is the first thing that you have to remember? Sociological jurisprudence, study of law along with societal welfare, correct? Now he has spoken about interests. Now we all have our own interest, right? So it could be reputation, it could be life, it could be something related to property. My interest is now my property interest is affected, my reputational interest is affected, so right to life is affected. So we all have our own interests. Now he has categorized interest into three parts. Okay, first is individual interest, that is pertaining to one individual. Interest related to liberty, life, liberty, reputation, property. So this is the first category of interest, individual interest. Second is public interest, interest of the state as a juristic person. Okay, interest of government, right? Next, that is public interest. Then comes social interest, general security, social institutional morals, conversion of resources, all of that, and environmental related laws. It could be good air, good water. So social interest, he has divided interest into three parts: individual interest, public interest, and social interest. Now he says that you have to first categorize these interests. Okay, this is interest related to reputation, property, this is social interest. Categorize all the interests and then check which interest requires legal recognition. Probably not all interest requires legal recognition. Now one person wants to take revenge. That is his interest. Can we give legal recognition to that? No, that would be against the law, right? So first classify the interest and then give legal recognition to those interests which requires legal recognition. And after that, what is the remedy that you can give? Give that. This is what Pound has told. First, you have to identify and classify the interest. Decide which interest deserves legal protection. Fix limits of such protection, to what extent you have to give protection, and then provide means to secure them, some sort of remedy, correct? This is what Roscoe Pound has told. So what does Roscoe Pound say? First thing what you have to remember here is he's a sociological jurisprudence. He believed in sociological jurisprudence and he has categorized three interests, and then based on those interests you have to function. And you should also balance the interest. That is also very, very important. Now, what was the criticism of Roscoe Pound's theory of law? Pound assumed that interest exists before law. But in reality, these interests are actually created and shaped by law itself. Right? So this assumption was not correct, whatever his assumption was. And then his theory does not give a clear or objective standard to evaluate or measure these interests. You have told we have to categorize the interest, but how do you measure it? How do you do it? That you didn't explain. And then the theory places excessive importance on judges because balancing of interest is mainly done by court. So complete pressure is on the judge. And then the distinction made by Pound between individual, public and social interests are unclear. Recognition of new interest depends on policy decisions, so merely listing interest does not help much in resolving actual legal disputes. This is what the criticism about Roscoe Pound theory. Clear? So Roscoe Pound focused on social engineering and social jurisprudence, sociological jurisprudence, but he also spoke about interest. Now that interest was criticized by a lot of other jurists. Got it? So what all did we cover? Jeremy Bentham, John Austin, and then we have Salomon and Roscoe Pound. Correct? 4 people. Next is H.L.A. Hart. So he was a British legal philosopher and a leading supporter of legal positivism. Again, he was a positivist. Now he explained positivism as the view that law is a system of rules or command and its validity does not depend on morality. What all we have covered till now, what is positive legal theory? The same thing even he has explained. Okay. So analysis of legal concept is important and should be done separately from sociology and history and moral or ethics. So you should not combine both. Okay, keep these factors aside and what law is separately. So this is what Hart has told. So the core idea of positivism is that law as it is must be kept separate from law as it ought to be. Clear? Then, very important, Hans Kelsen, pure theory of law. Now understand, this person has defined law. According to him, law should be read in its purest form. Okay, now all the above people, Jeremy Bentham, Austin, yes, even they said that law should be read as it is. But while they were defining law, Jeremy Bentham took help of utilitarian theory. Austin took help of sovereign command sanction. They connected, they mixed everything. They did not say what is law in its purest form. Now, Kelsen has told that law should be defined in its purest form. So, Kelsen was an Australian jurist known for pure legal theory, which studies law in a pure form separate from morality, religion, politics, or sociology. He was a legal positivist and focused on what law is, whether it is just or not, doesn't matter. Did it pass from a valid authority? Then yes. So Kelsen described as a normative science, not a natural science. Law deals with ought, norms, not cause and effect. What do you mean by that? What is natural science? Now, when it rains, the floor is going to wet. When I lit, it catches fire. So this is natural science, facts. But according to him, law is not natural science. It is normative science. What is normative science? What ought to be? What should be if this happens? Now, if a person steals, you should be punished. What ought to be? That is normative science. So he has told law is not a natural science and it is normative science. Clear? So according to him, sanction is essential to law, but he preferred the word norm. What are norm? Norm is rules. According to him, there are norms, there are rules. And what is the highest norm? That is the base norm from where all the other norms are derived. The base rule where other rules are derived, that is called as a grund norm. What is it? There are norms, that is the rule, set of rules. Now, the base norm through which all the other norms are derived its value, that is called as grund norm. And what is it? It is the Constitution of India. Correct? It is the Constitution of India which is the base where all the other statutes gets its power from whom? It gets its power from the Constitution of India, and grund norm is the Constitution of India. Okay, so he has explained the hierarchy of all the norms where each lower norm derives its validity from the higher norm. And what is the highest norm? It is called as a grund norm. Okay, so at the top of this hierarchy is the grund norm, that is the basic norm whose validity is presupposed, not derived from any other norm. So for example, grund norm is the Constitution of India. Superior norm, IPC, your BNS, all of that, CPC, all of that is superior norm. Who are the subordinate norm? Rules, regulations, notifications, all of that is the subordinate norm. The hierarchy of norms. Clear? So now coming to the criticism of Kelsen's pure theory of law. See, Kelsen is he's talking about grund norm. But did he tell how do you measure grund norm? No. He doesn't talk about how do you measure grund norm. So that was the first criticism. So unclear grund norm. It is difficult to identify the grund norm in every legal system, and Kelsen did not provide any clear test to measure when a grund norm is effective. Second, so Kelsen talks about when do you say a law is valid according to him? When the total legal system is effective. That is what he says. But how do you measure this effectiveness now? Did he tell that? No, he doesn't define that. So that is the second criticism. Next is the theory does not specify how long effectiveness must exist. Now, for example, let's say some people stop following law for 1 year, 5 years. Then does that become invalid? There is no time period which he has mentioned. Now, this is a third criticism. And then to analyze Grun norm, one must rely on sociology, history, politics, or morality, which contradicts Kelson's claim of pure legal theory. Very, very important criticism. He is telling it is pure legal theory. That means what? Law has to be read it in its purest form without taking anyone's assistance, without taking any other help, correct? But to talk about Grun norm, to see which is Grun norm, you need to understand, you need to take reference of history, sociology, politics, morality. So that time it is contradicting this pure legal theory which says law has to be read it in its purest form. Here we are not reading law in its purest form. So this is contradicting. Correct? Understood? So Kelsen supported primacy of international law, but in practice, most states give priority to their domestic law itself. This was the another criticism which makes the law unrealistic. Clear, all of you? Yes? Okay, so we are done with all the theories now, all the definitions from different jurists. What is law according to them? All right? So quickly, we have covered Jeremy Bentham, and then John Austin, and then Salamand, and then Roscoe Pound, and then Hart, and Kelson's pure theory of law. Yes, let's continue. Alright, now coming to different schools of law. Okay, there are different schools of law who have defined law, what is according to them. Correct? Now, first school of law is the natural school of law. What is this natural school of law? Natural school of law is based on these three things: reason, justice, morality. Now, law is based on what according to natural school of law? Reasons, justice, and morality. Okay. So, natural law theory states that certain rights are inherent in human beings by nature and can be discovered through reasons. So there are certain rights that are already inherent in human beings and it has to be discovered through reasoning. So natural school of law first focuses on reason. It believes in the existence of a higher moral law which is superior to man-made law. Now human beings makes law. Man-made law, human law. Can they go against morality? If they go against morality, will that be accepted? Of course no. So human laws are valid only if they conform to moral principles. Correct, right? There is a close link between law and morality under this school. So this school links law with morality. Law is not merely command or statute but an instrument to achieve justice. So reason, justice, morality. Understood? First, reasons. Why do we say it is reasons? Because according to natural school of law, certain rights are already inherent in human beings by nature and they can be discovered how? Through reasons. Why do you say justice? According to natural school of law, law is not merely command or statute. It is an instrument to achieve justice. Second point. Morality. Why do you say morality? Because there is a close link between law and morality under this school, and most importantly, this school says human laws are valid only if they conform to moral principles. Correct? If human laws are made where it is against moral principles, will that law be accepted? No. So that is what natural school of law focuses on. Clear, all of you? Now, under natural school of law, there are multiple theories. There are 4 theories. First is ancient theory. What have ancient theory, medieval theory, Renaissance theory, and modern theory? 4 theories are there. What are those? Ancient theory, medieval theory, Renaissance theory, and modern theory. What is this ancient theory? According to ancient theory, simple. Law is rooted in justice, reasons, and nature. Simple as that. So according to this theory, law is the highest reason implanted in the nature. Right? Next, medieval theory. Medieval theory, law is derived from God and divine will. So it is based on theological foundation. Law is considered a part of dharma. They have connected it with God. It is what comes from the divine will. So here, as per this theory, law of God, natural law, man-made law is human law, lex aeterna is the law of God. So basically in this theory what happened, they have told that law is derived from God and divine will. And then Renaissance theory, shift from God to reasons. Okay, so shift from saying law comes from God to law comes from reasons. So it is based on rationalism, more secular and political. This is what happened in this theory. So Renaissance is the shift that happened, okay, rebirth that happened from law is derived from God to reasons. It comes from reasons. Next is the modern theory. What is modern theory? Revival of natural law in the modified form. How it is required to the current situation, current society. You are changing the theory as per the current modernized situation. Okay. So reaction against strict positivism and historical school. Emphasize justice, fairness and harmony in the society. This is what is required in the current generation, right? In the modern world. What is required? Justice, fairness, harmony and society. So this is a shift that happened from ancient theory to medieval theory to Renaissance theory and modern theory. Ancient theory, justice, reasons. And then the shift happened where they say that law comes from God. It is the divine will, right? And then the shift happened in Renaissance theory where it doesn't come from God. It is actually reasons, shift from God to reasons. And then comes a modern theory where they told that revival of natural law in the modified form, focusing on justice, fairness, harmony in the society. Clear all of you? So these are the theories under natural school. So importance of natural school of law forms the basis of human rights, influences constitutional value, provides moral justification for law, acts as a check on arbitrary state power. If they are going against morality or not, check who keeps natural school of law. Yes? Alright. Next comes analytical school of law. Analytical school of law is something that you already know now. Analytical jurisprudence, Jeremy Bentham, father of analytical jurisprudence. So this talks about positive legal theory. Read law as it is. Who all talks about this? Jeremy Bentham, John Austin, Kelson, all of them talk about analytical school of law. So everything together they have given in analytical school of law. Quickly let's see. Analytical school of law studies law as it is, positive legal theory, not what it should be. It is also called as positive school of law. So another name for analytical school of law, positive school of law. Remember, they can ask what is positive school of law. It's the same thing. Now for Austin, what it is, it has three essential elements: command, duty, sanction. And then Kelson further developed pure legal theory. So at the top is the grund norm, below is the superior norm, and then is the subordinate norm. It's the hierarchy. So done with analytical school of law. Simple, we have already covered this. Then comes the historical school of law. This school believes that law is a product of historical and evolutionary forces, not sudden legislation. It's not something that has happened quickly. It's something that came over the period of time. This is what historical law says. So they focus on customs, traditions, social habits and conventions of society. Based on these customs, traditions, law has come into force in the current situation. It's not something that came up all of the sudden. So this is historical school of law. And then comes Savigny's theory. Law is not universal. It varies with people, culture and time, like language. Custom is superior to legislation. This theory focuses on custom. Okay. Right. So legislation is the last stage of lawmaking. Jurists and lawyers are more important than legislation, right? Who interpret law, they are more important. So this is about Savigny's theory. And then philosophical or ethical school of law. The school believes that law and ethics are closely connected. Law must contain moral and ethical values to command respect in the society. Law aims to harmonize individual will with the general will of the society. It has to coordinate, right? Individual will and what society requires. So societal will, individual will has to come together, and that is the valid law, right? It must harmonize between the both. This is ethical school of law where they connect law and ethics. Simple. And then So this is very important. The second point, law must contain moral or ethical values to command respect in society. Now a law is made which is immoral. Does that, do people respect that law? No. For you to command the respect in the society, that law has to be moral, ethical. That is what ethical school of law focuses on, which is also called as philosophical school of law. Then comes sociological school of law. What is this? Law studies the relationship between law and, just a minute. Yeah. So law studies the relationship between the law and society and treats the law as social phenomenon. Law is influenced by social needs, social facts, what society requires. Based on that, law is made. Okay, what society needs, society requires this, law is made for that. It is that. So not just logic or rules, it views law as the means of social control and a tool to achieve social welfare. Alright? And then comes realistic school of law. It defines law in terms of judicial process and court decisions. Very important. What realistic law says? It's not what is written in the statute. It is what court applies. That is law. Just because it is written in statute doesn't have value. It has value when court applies it. That is what realistic school of law says. Law is what actually courts do, not merely what is written in the statute. Alright? So this is what realistic school of law says. So we are done with all the school of laws. Firstly, natural school of law. What is natural school of law? Justice, fairness, justice, reason, and morality, right? It focuses on these three things. And then comes under natural school of law, we have four theories. And then we have analytical school of law, who talks about positive legal theory. And then historical school of law, who says that you need to consider customs, traditions. Law is something that has come over the period of time, not suddenly. And then Savigny's theory, who focuses on custom. And then according to Savigny's theory, who are important? Jurists, lawyers are more important than legislation. And then ethical school of law, who connects law with ethics, correct? Who says that if at all law is made and that is immoral, can it command respect? No, it cannot. And then sociological school of law, who connects law with society. What society requires, based on that you make law. And then realistic school of law, who says that just because it is written in the statute, is it sufficient? No, it is what courts actually do. How do they interpret it? How do they put it in force? So this is the schools of law. So as I told, this chapter has three parts. What is it? First part, you have all the definitions from all the jurists. That part is done. And then the second part is schools of law. Even that we are done with schools of law. So the last part of this chapter, that is sources of law. Alright. So before that, what are the different types of law that are there? Mandatory law, that you have to follow, pay tax. There is an obligation, mandatory. And then prohibitory law. In your criminal law, they say that you should not do certain things. Right? This is prohibitory law. And then permissive law, contract law. It gives some kind of rights on you. It gives you permission to enter into contract. So it allows the conduct without compelling or forbidding it. So these are the three types of law. And then, important, laws are made effective when? How? So by awarding damages. Yes. So if a person disobeys the law and causes injury or loss, the law makes him pay compensation. So to the affected person. This is how laws are made effective. Second, by enforcing the performance of obligation. Now a person has told that he will be performing, but he doesn't. At that time, law can compel him perform. Okay, first remedy is damages. That is always there. Compensation. But the next one, when you have told you will be performing something, court compels, you have to perform it. Okay. And then by preventing disobedience. So laws act as a deterrent by discouraging people from breaking the rule. Now traffic rules, it is there, you know that if I break the rule, then I have to pay penalty. Next is by punishment. Law imposes penalties or punishment to ensure obedience. Okay. So these are the ways how laws are made effective. Yes. Then comes the last part, that is the sources of law. Now we have two sources of law, primary sources of law and secondary sources of law. Source of law means what? Your chapter heading, from where the law has been derived, right? Primary source of law is the main and direct source of law, from where the law has directly been derived. Secondary sources of law, when the primary sources of law are not available, at that time secondary sources of law are used. Okay, first we will understand what are the different primary sources of law. So the very first type, it is customs. Correct, there are certain customs that are recognized by law, right? So customs, and then we have judicial precedents, and then we have statutes and legislations, we have personal laws. All of these are primary source of law. So we will check one by one. First primary source of law, customs or customary law. It is a primary source of law. Customs means what? It is long established practices which is followed by people, something that has been followed from ages. So recognition in Indian law, Article 13 Constitution of India includes custom or usage having force of law. See, customs are the oldest source of law and earlier regulated society before statutes or courts. Even before statutes and court was there, custom was there, no, practices, traditions was being followed. So that is customs. Now we have classification of customs, customs without sanctions and customs with sanction. Custom without sanction means what? There are certain customs that is being practiced, but you cannot punish the person who disobeys it. So customs without sanction. Example, now we have to touch elders' feet. That is a custom that is there. But if someone doesn't follow it, can you punish that person? No, because it is customs without sanctions and it is not binding. But we have customs with sanction, those customs which are recognized by law, right? And if you disobey it, then you will be punished. It is customs with sanction, those customs which are recognized by law, and if you don't follow that, you will be punished. Alright, now Hindu marriage, according to Hindu marriage, we have monogamy, that is just one marriage. So this is a custom that has been followed and this is recognized by law. There are certain marriage rituals that are recognized by law. If you don't follow that, you will be punished. Alright, so this is your customs with sanctions. Clear, all of you? I hope everyone is clear with this. Now, what are the essentials of valid customs? We have certain essentials. First, customs must be very old, something that just came up yesterday. Can you treat it as customs? No, it has to be something that has been following. And then customs must be clear and definite, not vague. And then it must be fair and sensible. It must be continuously followed and treated as binding. It should not be optional. One person following, the other person not following. No. And then the custom must not violate the statute law. It should not violate morality, public policy. Customs must be generally accepted by the community, not by few individuals. Something that everyone has accepted. The custom must be followed without any disputes or objections. The custom must not conflict with other existing customs. So these are the essentials of valid customs. Clear, all of you? The primary source of law, first one is custom, customary law. Those customs that are recognized by law. Alright? Next comes the second one under primary source of law, that is judicial precedent. What do you mean by precedent? I will give an example for you now. See, now there is one school, it expels the student without even listening to that student. What has happened? There is a school that has expelled a student without even listening to that student. The others, that's whatever student wants to say, his part is not listened by the school itself, and that person is expelled. Now he files a case. Can he? Yes, of course. So now the court has decided, okay, this is the facts of the case. This is the reasoning that has been given in this case. This is the legal principle laid down in this case. This is the judgment. All of that comes up in this particular case. Now the final judgment is that, what is it? The person, without hearing the other person, you cannot expel him out of the school. This is invalid, is what court held. Now, similar situation happens. Now, this case is done. Similar situation happens where another school expels a student without listening to him. Can this other court, can this court, where it is listening the second case of which is having similar facts, should it follow the earlier court's decision? Is my question to you. Now, the court has passed this decision where, without listening to the other person, if you take any decision, it is invalid. Should the other court, where such similar case has come before it, should it follow this earlier court's decision? Yes or no? Yes, this is called as precedent, where one court's decision is binding on the other court. This is called as precedent, where the decision of the court is binding on the future courts. This is called as precedent. Clear? Now a higher court has passed a decision. Is it binding on the subordinate court? Yes, it is binding. They have to follow. They don't have any option. Got it? This is called as precedent. Precedent is the past court decision which guides the future cases. Only decisions that lay down a new rule or principles are precedents. Following past decisions are called as doctrine of stare decisis. So this is based on a doctrine of stare decisis. What do you mean by doctrine of stare decisis? It means to follow the past decisions or to abide by what has already been decided. This is a precedent is based on what doctrine? Doctrine of stare decisis. So what is the basic rule? The legal principle settled by earlier court decision is binding and should be followed in similar future cases. Like cases should be decided alike. When you have similar cases, treat it alike. Else there is no value for judgment. There is no value for justice. Correct? So purpose is to bring certainty, uniformity, stability in law. Helps the people know that law in advance and trust the justice system. So this is doctrine of stare decisis. Now there are certain important points here. Higher court decision, is it binding on the subordinate court? Higher court decision, is it binding on the lower court? Yes, it is binding on the lower court. Now there are two high courts. High court of one state, the high court of other state. Is this high court's decision binding on this high court? No, it is not binding. It is not mandatory. It has persuasive value. They can take the reference of it, but not mandatorily binding. I'll repeat. Higher court decision is mandatorily binding on the lower court, but not on the other high court. Alright. So a high court decision is binding on all subordinate court within a jurisdiction. Decision of one high court is not binding on the other high court. They have persuasive value only. That is, they can take reference of it, but not mandatorily binding. So if there is any conflict between the decision of co-equal benches, the latter decision is generally followed. Okay. So single bench is the smallest bench, divisional bench, it is not double bench, it is divisional bench. 2 judges, full bench, 3 or more, it is called as full bench. So decision of the larger bench is binding on whom? On the smaller bench. If a bench disagrees, the matter must be referred to the larger bench. Clear, all of you? So now Supreme Court precedents. See, Supreme Court is the highest court of the country, right? Now Article 141 says law declared by Supreme Court is binding on all the courts in India. Okay, Supreme Court has passed a decision, it is binding on all the courts in India. Only ratio decidendi. Now what is ratio decidendi? Will come to that. So pre-constitutional Privy Council are binding unless overruled by Supreme Court. So before Supreme Court we had constitutional privy council and all of that. That is binding only if Supreme Court accepts it. All right. Next. Supreme Court and Precedent, Article 141 gives binding force. All courts in Article 141 means all courts except the Supreme Court itself. And Supreme Court is not bound by its own decision. Very, very important. We have seen what? High Court passed a decision. Subordinate court has to follow that. Now Supreme Court has passed a decision. Should it follow again in the next, in the similar case? No. Supreme Court is not bound by its own decision. This is one exception for only Supreme Courts. Clear? So in practice, how it happens? Yes, Supreme Court follows its earlier decision. It may depart only for special or extraordinary reasons, especially if the earlier decision is wrong or harmful or public welfare. But as per Article 141, Supreme Court is not bound by its own decision. This is something you have to remember. Next, very important, what are the different kinds of precedent? First is declaratory precedent. Declaratory precedent is already it is declared. There is no new rule of law that is there. That is declaratory precedent. When you are making a new rule of law, that is original precedent. So what is it? Declaratory applies to already existing rule of law. This is you are creating a new rule of law here. Okay. Persuasive precedent. You only tell me now. What is persuasive precedent? Is it mandatorily binding? No. You can take a reference. Okay. It is not binding. Court may consider but need not follow them. And then absolutely authoritative precedent. That means mandatorily you have to follow it. No other option. Conditionally authoritative precedent. What is conditionally authoritative precedent? You have to follow. But if you feel that it is against morality, then you need not follow. Absolutely authoritative precedent, you have to follow, no other option. Conditional precedent, authoritative precedent, yes, you have to follow. But if it is against morality, you need not follow it. Clear? Yes. So next, very, very two important concept. What do you mean by ratio decidendi and what do you mean by obiter dicta? Tell me, what do you mean by ratio decidendi? Now, in the same case what I had told, that is the school had expelled a student. In that, what was the principle laid down in that case? No student can be expelled unless giving him an opportunity of being heard. You have to listen to that person, then you take a decision. Without listening to that person, you take a decision, then such decision is not valid. Okay, this is the principle laid down in that case. This is the ratio decidendi. What is ratio decidendi? The reasoning behind giving that judgment. What is the reason? Why is the judge telling this decision is invalid? Because you did not give him the opportunity of being heard. So this is the principle laid down in this case. This is called ratio decidendi. Now you tell me, is this binding or not? Should the other court follow this principle or not? Yes, of course. Correct? No, this is the main reason why the judge passed this decision. This is binding. This is the reasoning behind the case. Correct? So what do you mean by ratio decidendi? It is a reason for the decision. It is the legal principle on which the case is decided. And is this binding? Yes, this is binding. Clear? Now, the same case where student is expelled. Now in this case, court says, see, court gives a suggestion to school that you have to have certain disciplinary community, you need to have this community, you have to do that. All of those observations court passes. Okay, it is not directly relevant to the case, but court judges pass some comments. They give their observation. What is this called? This is called as obiter dicta. Judges, whatever comments they have passed, whatever other observations they have given, that is called as obiter dicta. Okay, what is obiter dicta? Something that is said by the way. Whatever judges say while passing the main decision, judges would have passed certain comments, given certain observation, gave certain observation. So all of these are obiter dicta. Now you tell me, is this obiter dicta binding or not? No. Understood? Ratio decidendi is the principle laid down in the case and this is binding. Obiter dicta is the comments passed by the judge. It is not binding, but it has what value? Persuasive value. Other courts can take reference of this, but not mandatory. Is there any mandatory obligation they have to follow? No. But is there any mandatory obligation they have to follow the ratio decidendi? Yes. Understood? So we have seen what is precedent, doctrine of stare decisis. What do you mean by ratio decidendi? What do you mean by obiter dicta? Very, very, very important. You should never forget this. Alright? So legal effect, obiter dicta are not binding. They have what value? Persuasive value only. Clear? Yes. So we are done with customs and then judicial precedents. Now comes the third primary source of law, that is statutes or legislation. Of course, legislation. So legislation is what? Means making law by the authority empowered by the constitution. Now who gives power to legislation to make law? It is the constitution that gives power to legislation to make law. Now we have two types: superior legislation and subordinate legislation. Superior legislation is parliament, your state legislation, which directly derives the power from the constitution. Subordinate legislation, who gives the power to them? Parliament gives the power that you also make the law. Alright? So superior legislation made by the sovereign authority or authority deriving power directly from the constitution, acts of the parliament, ordinance issued by president, governor, all of that. Subordinate legislation is what? It is made by the authorities other than the sovereign body. Its validity depends on the superior authority. So executive makes rules, regulations, notifications. Judiciary makes rules for relating court procedure. Judiciary role is interpretation. Alright. So municipal bodies make bylaws. Autonomous bodies, your universities, education universities, they make bylaws. All these are subordinate legislation. What is the another word for subordinate legislation? It is delegated legislation. Got it? Clear? Yes. So legislation is written law made by the constitutionally empowered authorities, and it is of two kinds: superior legislation made by parliament and subordinate or delegated legislation made by authorities under the power delegated by the legislation. Clear? Next are the personal laws. We have personal laws pertaining to that particular community or religion. We have Hindu law, Muslim law, all of these come under personal laws. So personal laws apply to individual based on the religion. Courts apply personal law when there is no statutory law or customs covering the issue. We have Hindu personal law. So sources of Hindu personal law are Shrutis, Smritis. And then we have Mohammedan law. Sources of Mohammedan law, Quran, Hadith, all of it. Alright. So this is the personal law, which are religious based law applied by courts in the absence of statutory law. Right? Alright. So we are done with primary source of law. Now secondary source of law. When primary source of law is not available, courts check secondary source of law to give justice. Now secondary source of law is what? First one is justice, equity, good conscience. When primary source of law is not available, the decision is passed based on justice, equity, good conscience, fairness. Alright. So when no statute, custom or personal law governs the issue, court decide the case based on fairness, reasonableness and conscience. This is the secondary source of law. And then we have sources of English law. Of course, India has a lot of influence of the English law. Now there are certain sources of English law that is also considered. So Indian law is largely influenced by English law. So the main sources of the English law are: first is common law. What is common law? Judge-made law. Right? We have civil law. Civil law legal system is there is a written codified act. Common law legal system is judge-made law. So judge-made law are developed through judicial decisions over time based on customs, precedents and legal writing. Now it is unwritten law common to the whole of England. This is the source of English law. Now we are talking about source of English law, and that source of English law is a secondary source of law. Alright, in certain cases it is considered. First source of English law is common law, that is judge-made law. Next is law merchant, that is customs related to trade practices. So consists of customs and usage of trade. So law merchant governs trade and commercial transactions. Next is principle of equity, very important. What do you mean by principle of equity? Now you giving equitable remedies. What is equitable remedies? Specific performance. Yes, pay compensation, that is the remedy. But when I say that you have to perform what you had promised to perform in contract, you had told you will be performing this, and I am telling you no compensation, you perform whatever you had promised to perform in the contract. That is specific performance, compelling the other party to finish the performance. Okay. Next is equity of redemption. Now when a loan is taken and the property is given as security, at that time on the due date the loan is not repaid, due date is over. After the due date, granting permission to repay, and after the due date the bank has the authority to sell that security and recover the money, but giving that person more time. This is equity of redemption. Now trust and beneficiary rights, and then common law and equity courts are merged. Yes, so compensation is also granted and equitable remedies are also granted. Next source of English law is statute law, law made by parliament or delegated authorities. It is a written law. These are all the sources of English law, and sources of English law is the secondary source of law. Got it? Everyone clear till here? Yes? Alright. Next is the last concept. What do you mean by mercantile law or the commercial law? See, as the name suggests, mercantile law deals with trade, commerce, business transactions. It applies to commercial activities of the people in the society. It covers all the legal principles relating to business dealings. The most important feature of mercantile transaction is the existence of a valid agreement. So it is developed, it is also called as law mercant, lex mercantoria. It is developed from customs and usage of trade in England and later became a part of common law. Something these traders, these businessmen have been following as a custom that later became a law, right? And then we have sources of mercantile law, important. So we have law mercant, common law, principles of equity and statute law. This is very important. Sources of Indian mercantile law. So Indian mercantile law is derived from four main sources. English mercantile law, we have derived from them. Okay, our law is derived from them. They ruled us for so many years. So English mercantile law, acts enacted by Indian legislature and judicial decisions, and then customs and trade practices. First is English mercantile law. Now English mercantile law is largely based on Indian mercantile law is largely based on English mercantile law. Necessary modifications have been made to suit Indian conditions and local trade practices. As per our requirement, modifications has been made. Next, acts enacted by Indian legislature. We have a lot of acts which is for trade, right? We have Indian Contract Act, Sale of Goods Act, Negotiable Act, and then Indian Partnership Act, Arbitration, Insurance Act. All of these are for promoting trade, are for trade, right? So statutory law overrides all other sources. The written law overrides everything. And then we have judicial decisions. Judges interpret and explain the statute. When law is silent, the court decides the case based on justice, equity and good conscience. Now customs and trade usages. Though law is largely codified, customs and trade usages are still recognized. Yes, so customs and usages are valid unless they are inconsistent with statutory laws. So Indian mercantile law is derived from English mercantile law, statutory enactments, judicial decisions and customs and trade usages with statute having overriding authority. This is, if you remember this, done. Yes students, so we are done with sources of law chapter 1, right? So See you in the next class with another chapter for revision. Alright, thank you.